is Juneteenth Radio, and we are with the United States District Court, Southern District of Florida, case number 126CV 20609 KMW. President Donald J. Trump versus Internal Revenue Service Settlement Agreement. Introduction. This is a civil lawsuit, the case brought by President Donald J. Trump Jr., Eric Trump, and the Trump Organization, LLC, against the Internal Revenue Service, the IRS, and the United States Department of the Treasury defendants under 26 U.S.C. 610326, U.S.C. 7431, and 5 U.S.C. 552 AU 10. In the interest of resolving the dispute between the parties, they hereby stipulate and agree as follows. Recitals. On January 29, 2026, plaintiffs filed a complaint in the United States District Court for the Southern District of Florida, stating that a former IRS employee contractor, Charles Littlejohn, had illegally obtained access to and illegally disclosed plaintiffs' tax returns and or tax return information to media outlets in violation of the Internal Revenue Code and the Privacy Act. Counsel for plaintiffs have indicated that before this settlement, they would intend to amend their complaint, including in order to likely add a putative class claim. President Trump has also submitted 2 claims for relief pursuant to the Federal Tort Claims Act based on an unlawful raid on Mar-a-Lago in Palm Beach, Florida in August of 2022 and the Russia collusion hoax throughout his first term as president and beyond, together, the pending agency claims. Those claims are currently pending at the administrative level. The conduct alleged in this case and in the pending agency claims is representative of the sustained use of the levers of government power by Democrat elected officials, political and career federal employees, contractors, and agents in order to target individuals, groups, and entities for improper and unlawful political, personal, and or ideological reasons, lawfare, and weaponization. Other well-known examples of lawfare and weaponization include the Biden administration's abuse of the FACE Act, the Biden administration's wrongful labeling of certain parents as domestic terrorists, and the IRS's targeting of groups based on improper ideological criteria. To bring a case and the pending agency claims to a close forever. And finally, the parties have determined to settle the case and pending agency claims effective May 18, 2026 effective date. Relief and legal authority. As sole and complete relief for allegations in the case and the pending agency claims, plaintiff President Donald J. Trump and the other named plaintiffs in this case and in the pending agency claims will receive a formal apology from the United States, but will not receive any monetary payment or damages of any kind. In exchange for the relief provided in the settlement agreement, and except as provided herein, plaintiffs hereby release, waive, acquit, and forever discharge defendants and the United States from, and are hereby forever barred and precluded from prosecuting or pursuing any and all claims, charges, counterclaims, causes of action, appeals, or requests for any relief, including injunctive, monetary, damages, tax payments, debt relief, costs, attorney fees, expenses, and or interest that as of the effective date have been or could have been asserted by plaintiffs in the case or the pending agency claims by reason of, with respect to, in connection with, or with which arise out of matters in the case or the pending agency claims. To provide a systematic process to hear and redress claims of others who, like plaintiffs, state that they incurred harm from similar lawfare and weaponization, the Attorney General of the United States agrees to create the Anti-Weaponization Fund, subject to the terms and limitations described herein. Composition and operation of the Anti-Weaponization Fund. An accompanying order of the Attorney General, issued within 30 days of the effective date, shall establish funding and any other relevant requirements, rules, conditions, terms, and waivers, which shall be treated as incorporated herein. The Attorney General may also change the formal name of the Anti-Weaponization Fund by order. The corpus of the Anti-Weaponization Fund's funding does not represent the value of any current claim by plaintiffs, but rather is based on the projected valuation of future claims, and accordingly the corpus of the Anti-Weaponization Fund's funding is not taxable income as the plaintiffs, who receive no economic benefit from this settlement agreement. The Anti-Weaponization Fund shall consist of 5 members. Within 30 days of the effective date, the Attorney General shall issue an order appointing the members, including the chair of the Anti-Weaponization Fund, with such order being treated as incorporated herein. One of the members shall be chosen in consultation with congressional leadership. The members shall serve until the Anti-Weaponization Fund is concluded as described below, unless they resign or removed, or are removed by the President, who can remove any member without cause. Any replacement shall be made by the same method as the initial appointment. A quorum is 3 members. A majority of a quorum is authorized to take action. Consistent with the settlement agreement, the Anti-Weaponization Fund shall have the power to determine its own procedures for submitting, receiving, processing, and granting or denying claims. The Anti-Weaponization Fund shall have the power to issue formal apologies, issue monetary relief owed to claimants as a result of their legal rights, grant claims in whole or in part, deny claims in whole or in part, defer review of claims, and receive and request evidence or other support for claims, including requesting information from or consulting with federal agencies on a quarterly basis or otherwise as directed by the Attorney General. The Anti-Weaponization Fund shall provide to the Attorney General a confidential written report that includes the name and address of each claimant who has received any relief and if so, nature of such relief. The Department of Justice or third-party contractor of the agency, as designated by the Attorney General, may audit the claims submitted pursuant to this agreement. The Department of Justice and or any other government agency may, to the full extent permitted by law, make referrals for investigation or prosecution or prosecute or take other law enforcement action to address any evidence of fraud. The Anti-Weaponization Fund shall cease processing claims no later than December 1st, 2028. In the event that there is balance remaining in the Anti-Weaponization Fund's accounts after December 15th, 2028, the Anti-Weaponization Fund shall transfer such balance before January 1st, 2029 to the Department of Commerce, Interior, or another appropriate federal government account as designated by the President. The recipient of any relief from the Anti-Weaponization Fund will have sole responsibility to comply with their own applicable federal, state, and local tax requirements that arise as a result of this settlement agreement and any relief from the Anti-Weaponization Fund. Limitations on claims. Submission of a claim to the Anti-Weaponization Fund is voluntary. Claimants can include entities. A claimant can choose whether to accept relief from the Anti-Weaponization Fund. If a claimant does so, the claimant must forego all other relief, including judicial relief, whether previously asserted or not. To be eligible for relief, a claimant must assert at least one legal claim, stating that the claimant was a victim of lawfare and or weaponization. In evaluating claims, the Anti-Weaponization Fund shall consider the totality of the circumstances, including the strength of the claim and supporting evidence, the claimant's actions, the claimant's actual damages incurred as a result of the lawfare and weaponization, reasonable attorney's fees paid by the claimant as a result of the lawfare and weaponization, any time the claimant spent in prison or otherwise in federal prison or custody as a result of the lawfare and weaponization, whether and to what extent the claimant has already obtained any form of relief for the lawfare and weaponization from any source. Other factors the Anti-Weaponization Fund deems just and appropriate. A claimant who already has a claim pending in court or administrative proceedings may be eligible for relief, subject to paragraph VB. The Anti-Weaponization Fund shall take reasonable steps to protect private, personal, and financial information submitted to them under this settlement agreement. The Anti-Weaponization Fund shall impose controls and systems to avoid fraudulent claims. Enforcement. This settlement agreement is enforceable and challengeable solely by plaintiffs, defendants, and the United States. Because the claims process is voluntary, there shall be no appeal, arbitration, or judicial review of claims, offers, or other determinations made by the Anti-Weaponization Fund. Denial by the Anti-Weaponization Fund, the pendency of a claim, or rejection of an offer by a claimant does not preclude a claimant from seeking judicial or other relief outside the Anti-Weaponization Fund process, if otherwise allowed by law. Integration and counterparts. This settlement agreement, including the accompanying orders by the Attorney General, constitutes the entire agreement of the parties, and no prior statement, representation, agreement, or understanding, or written, that is not contained herein will have any force or effect. This settlement agreement may be executed in counterparts. All executed counterparts and each of them shall be deemed to be one in the same instrument. Modification. This settlement agreement may be modified only with the written agreement of the parties. Duties consistent with law and regulations, nothing contained in this settlement agreement, shall impose on defendants or their agents, employees, or contractors any duty, obligation, or requirement, the performance of which would be inconsistent with federal statutes. The parties to the settlement agreement shall defend against any challenges to it in any form. Severability. Should any provision of this settlement agreement be